year, the liquor license, so great for that. And we're also celebrating the fact that on the 20th of February was the day that the bill to prohibit, or to undo prohibition, undo the 18th Amendment, was first introduced in Congress. So a lot of drinking and debate. I hope to see you guys there. Without further ado, I'll turn it over to Joe for our introductions.
Well, thanks everyone for coming. Let me just take a minute to introduce our speakers today. Today we'll have Professor Mortensen commenting. Professor Mortensen is the James Phillip Professor of Law here at Michigan Law. He's a legal historian, constitutional litigator, and award-winning teacher who specializes in the constitutional and political history of early America. He's widely published, and before coming to the Michigan Law faculty, Professor Mortensen worked at the law firm Wilmer Hale and in the President's Office of the International Criminal Tribunal for the former Yugoslavia. Early in his career, Professor Mortensen clerked for U.S. Supreme Court Justice David Souter and Judge J. Harvey Wilkinson III on the Fourth Circuit. Prior to clerking, Professor Mortensen earned his J.D. from Stanford and his bachelor's from Harvard. And coming to us today from Texas is Professor Josh Blackman.
It's warmer there.
Yes. Since 2012, Professor Blackman has served as professor at the South Texas College of Law in Houston, where he holds the Centennial Chair of Constitutional Law. Professor Blackman is also an adjunct scholar at the Cato Institute, and in addition, he's a prolific author, having written multiple books, as well as more than 6 law review articles that have been cited nearly 1,000 times. Professor Blackman is also the president of the Harlan Institute and founded Fantasy SCOTUS, a popular Supreme Court fantasy league. Professor Blackman's commentary has been published in all the major newspapers, and he appears on all the major TV news stations. He's provided advice to federal and state lawmakers, testified before Congress, and been quoted during impeachment proceedings.
Two of them.
Two of them.
Back to back.
Yes. After finishing law school, Professor Blackman clerked for Judge Kim Gibson in the Western District of Pennsylvania, as well as for Judge Janny Boggs on the Sixth Circuit. Professor Blackman graduated from George Mason University School of Law with his JD and attended Pennsylvania State University for his undergraduate degree.
Which for once was actually better than Michigan. Well, it doesn't happen often,
Yes.
but this year was.
Please join me in welcoming our speakers.
Thank you. Thank you so much. It's a pleasure to be here. Also, Professor Mortensen, thank you. I've read a lot of his work over the years. It's been very, very important, especially on the executive vesting clause, removal power. I'm actually grateful to have him here to share his thoughts. The topic today is invasion. Invasion. I'm going to raise 4 questions and not give many answers. That's my goal. On Inauguration Day, President Trump signed a proclamation guaranteeing the state protection against invasion. Trump determined that the federal government had failed in fulfilling its obligation to the states at the southern border and would take measures to fulfill its obligation to the states. 1 year earlier, in 2024, Texas Governor Greg Abbott also declared an invasion at the southern border. Most critics saw these actions as partisan statements with no legal effect. I disagree. There are important constitutional ramifications to declaring an invasion. If there is an invasion, both the federal government and the states receive additional war powers to repel that invasion. Federal laws that conflict with those war powers may give way. And, topic perhaps for today, the children of invaders may not be entitled to birthright citizenship. So the concept of an invasion may seem obscure today, but it was certainly in the mind of the framers of the Constitution. Pop quiz. How many clauses of the Constitution mention invasion? Pop quiz. Anyone know the answer? 1, 2, 3. Say it.
4.
The answer is 4. Anyone know that? 4. Who learned about this in common law? I sure didn't. 4 clauses of the Constitution reference invasion. Some scholars think these issues are open and shut. I don't. Some scholars think that invasion must be hostile, and that peaceful migrants cannot be invaders, and that courts can determine whether, in fact, there is an invasion. Again, I'm not so sure. So here are the 4 questions I want to answer, and warning you, I don't have answers to them, but I will raise the questions. The first question is, what is an invasion? The second question is, who can declare an invasion? The third question is, what happens to other federal laws during an invasion? And the fourth question, are the children of invaders birthright citizens? Okay? So the first question, let's start with, what is an invasion? The Supreme Court has not defined this term, it just hasn't come to the court. There have been a couple lower court decisions, the Ninth Circuit, the Third Circuit, and maybe one or two others, that said an invasion means a hostile armed army or a foreign incursion. If you actually pull these decisions, though, there's not much analysis there. There's at most a few sentences, and it would not even pass originalist muster by any sense of the word. They kind of just asserted it, maybe citing a Federalist paper or something. There's not much there, so I wouldn't put much stock in this. There's now an explosion of originalist scholarship on this, and as you might expect, it sort of cuts both ways. I'll give both sides. On the one side, you have Robert Nadelson, Andrew Hyman. Nadelson, I think, is one of the greatest living originalist scholars. He gets cited by Justice Thomas on a fairly frequent basis. And Nadelson and Hyman write that invaders do not need to be an organized, armed, or part of a foreign army. For example, during the founding era, Pennsylvanians used the word invader to describe basically peaceful migration. People from Connecticut into the Wyoming Valley of Pennsylvania. Okay? They cite over a dozen founding era dictionaries and other 18th century sources that an invasion does not need to be hostile and armed. All right? On the other side, the leading proponent is Ilya Soman. Now, Ilya is my professor at Mason, so I go way back with him, and I have a lot of respect for his work. He says that peaceful migrants cannot be invaders. He cites Madison Federalist 44, and Madison says an invasion is a foreign hostility. And in the report of 1800, Madison says invasion is an operation of war. Now, to be sure, I think these are good quotes from Madison, but I don't think they settle the debate. I think Madison's describing what they typically knew as an invasion, but he wasn't saying this is the only meaning of the word. Words can have multiple senses. Think of bear arms as it is in terms of a militia or individual right. There are different senses of a word. Okay? Now, President Trump's order observed over the last 4 years, at least 8 million illegal aliens were encountered at the southern border. 8 million. Just to give you a sense, the population of the United States in 1790 was 4 million. Okay. So imagine you describe a wave of migrants double the size of the population of the United States in the span of a couple years. Would that be an invasion? I'm not sure. But I don't know that the size actually matters too much. There was a case for the Supreme Court called Ex parte Quirin from 1942. This is a weird case. We had these Nazis wash ashore of the beach in Long Island, New York, and then they were ultimately executed as saboteurs. But the court said that these 8 people were invaders, so enemy invaders. So I don't think the number matters too much. So I'm going to table this for a little bit because I think we need more scholarship on this, to be completely candid. There's just not enough. I'm not made up my mind one way or the other. I think a corpus linguistics study would be helpful. That's a good way to decide what the word invasion means. There are other ways to determine meaning beyond looking at dictionaries and other corpora, as they were. The Constitution, again, uses the word invasion in several places. And the Constitution juxtaposes invasion with an external threat with insurrection, rebellion, or domestic violence, internal threats. In other words, the Constitution pairs these two. They say, okay, in the same sentence, you can deal with invasion and insurrection, right? Which would suggest that invasion and insurrection have a similar meaning. But then again, this brings us back to our question of last year, what is an insurrection? I'm sure you had the debates in this last year, maybe you did. This was an issue that people did not agree on. Some scholars in the Colorado Supreme Court said it's clear what an invasion is. And that Trump's conduct clearly fell as, insurrection. It was clearly an insurrection. The Supreme Court did not reach the issue on the merits. They did some other weird stuff. I researched this topic a bit, and I came to a conclusion that maybe it's not popular. I don't really know what an insurrection is. I actually don't. It's a very hard term to define. This is very fact-specific, based on a lot of different factors. And frankly, it's a bit of a judgment call. You know, would you have said on January 6th that was an insurrection? Maybe. But 4 years later, look what's happened. Do you still view it as insurrection? I'm not so sure. Right? There's a political judgment saying, what is war? What is insurrection? What is invasion? I'm not sure that judges are in the best position to assess these complicated international dynamics. There's a doctrine, if you take in federal courts, the political question doctrine. This, in my mind, seems like the quintessential political question, which involves a lot of questions, both foreign and domestic. And in fact, the few courts to address the invasion clause have said this is a political question. Now, they said this in a different context. They said in the context of states declaring an invasion. They said, no, the federal government declares it. Well, now we have a federal declaration of an invasion. So I think, in my view, that whatever the original meaning says, if there's a political judgment that there's an invasion by the appropriate branch, I'll get to that, which appropriate branch it is in a minute, then I'm not sure that's something that courts are going to second guess, but we'll put that aside for a moment. Okay. So question number 2, who can declare an invasion? This thing is actually a very important question. The Constitution is quite clear. Who can declare an offensive war? Congress. That is clear. I will fight you on that one, that's true. I think the president might have some powers to repel invasions on his own, we'll get to that, but to declare a war, Congress. What about invasion? It actually turns out that the Constitution spreads this power across the different branches. I'll go one at a time. So again, as my friend said, there are 4 provisions of the Constitution that talk about invasion. 4. So first, and we read Ex parte Merriman, right? During the Civil War, President Lincoln suspended the writ of habeas corpus. Chief Justice Taney wrote in Merriman, you cannot do this. The Constitution says Congress can suspend the privilege of the writ of habeas corpus in cases of rebellion or invasion. That suggests that Congress decides when to suspend the writ, and for Congress to suspend the writ, they have to decide there's an invasion, right? So Congress clearly has the power to declare an invasion, to determine when they need to suspend the writ. Again, I don't think the president can suspend the writ by himself. Lincoln, I think, was wrong. Taney was correct. If I can say that here. I think Taney was correct in Merriman. So at least Congress certainly has that power. Okay, there's a second reference to invasion. Congress has the power to provide for calling forth the militia to suppress insurrection and repel invasion. That is, Congress puts the laws in place of how the president can call forth the militia. But again, who calls forth the militia in case of invasion? The president. The president. This is good textual evidence that the president can decide when there's an invasion. In other words, he doesn't have to go to Congress, hey, Congress, there's an invasion, hey, call forth the militia. That's not what the Constitution says. And there's case on this. Go back to Justice Story, 1827, a case called Martin versus Mott. He said, this power to call forth the militia is confided in the executive of the Union. It's right there. This is 200-year-old precedent. So I think the president can declare there's an invasion to decide when to call forth the militia. The third one is what's part of the guarantee clause. Did you say Luther v. Borden in Fed courts or in con law? This is a case about the guarantee clause. And it says that the federal government must guarantee the state's Republican form of government. And this is a debate. If there's an insurrection in the state, what does the government have to do? But there's another part of the clause people forget about. It's not really involved in Luther. Insurrection is an internal threat. Invasion is an external threat. Right? Insurrection is the people in your own jurisdiction fighting each other. Invasion is people from outside the borders coming in. Okay. So the Constitution says the United States must protect each state against invasion. It's an obligation on the government. It's a guarantee. Now, it doesn't say which branch of the government makes such a guarantee. But again, we go to Luther v. Borden. Again, it was Chief Justice Taney. Started quoting it, but he had a lot of important decisions here. In Borden, the court wrote, this power is given to the president. And he says the president must move with dispatch during an exigency. Again, the president can use a militia to fight an invasion, fight an insurrection, but also to guarantee the states against invasion. I think Congress goes to declare an invasion, and if just for those who are curious, I think this is not subject to a filibuster. So I think Congress will declare an invasion tomorrow, if they so wished. They don't have to. Okay, I said there were 4. I'll get to number 4. Fourth, and this is the one that people are most afraid of. They don't like this one, but it's here. A state can engage in war if it is in such imminent danger as will not admit of delay to seek congressional consent. Again, so generally states cannot engage in war. But they can engage in war if there's an imminent danger and there's not enough time to seek consent of Congress. If they can seek consent of Congress, they have to do that. But there's another clause. If a state is being actually invaded, they have the same war powers. And the way I read that, they don't need to seek Congress's consent. In other words, Congress guarantees the state, you will not be invaded. If Congress doesn't keep its end of the bargain, the state's going to have war powers. That is a big deal. Again, it's clear. Whatever an invasion is, if a state's being invaded and Congress doesn't stop the invasion, the state then has war powers to stop the invasion. That is a big, big deal. That's why people are so concerned about this. It's happened before. So In 1874, always in Texas, right? The governor of Texas declared an invasion. There were Mexican marauders, as he called them. And he said that he has the right of self-defense. Initially, the attorney general opposed it, but then eventually he acquiesced. People forget about that one. So again, the Constitution gives Congress, the president, and the states the power to declare an invasion. Every branch has a role in this except for the judiciary. The courts have no role. So I think it's all the more reason for the courts to sort of not define what invasion is. Now, this is where the rubber meets the road. So, okay, declare invasion, so what, right? So what? What happens to other federal laws during an invasion? This is the big one. The Constitution gives certain functions to the states. These are called federal functions. Anyone remember Morgan's Harper from a couple of years ago, independent state legislature case? The Constitution gives the legislature of the states, which apparently means every state government, the power over elections. This is very significant, right? When you have a federal function, that's a unique role. So for example, if there's a vacancy in the House, the governor must schedule the election. If there is a vacancy in the Senate, the governor will generally fill that vacancy. The Senate can't fill it. It's the governor's power. When the Constitution gives a power to the states, unless it says otherwise, Congress can't regulate that. Statutory law does not override a federal function. If you are a state official exercising a federal function, you are exercising the supreme law of the land. You are. And Congress can't regulate that any more than Congress could perhaps ban the president's issue of a veto. So if in fact the states have these war powers, I said if in fact the states have these war powers, then what happens to statutory law? It's not clear to me that Congress can override it. So if a declaration of invasion is a federal function, that gives the president the powers that cannot be controlled by statute. This is a very, very big deal. I know why people are so afraid of this. Critics are concerned about this argument. Again, if the president of the states can exercise this federal function, the Constitution directly authorizes it. And under the Supremacy Clause, these actions would likely prevail over contrary statutory authority. Those actions would be prohibited if they conflict with a constitutional guarantee, such as due process or freedom of speech. Right, the Constitution is on the same level. For example, only Congress can suspend the writ of habeas corpus in case of invasion. President and states can't take this step. But in case of an invasion, where the president or maybe the states are acting pursuant to this federal power, federal law might give way. One of such law is the Immigration Nationality Act. Yeah. In 2024, Governor Abbott put these floating structures in the river of the Mexican border, these buoys. And the Biden administration said, oh, this violates the River and Harbors Act, a federal law involving placing obstructions in bodies of water. Texas says, no, it doesn't. This is not navigable water. It's a different story. But they also said, whatever the statute says, our war powers trump it. Not like trumpet. It trumps the statute, right? Trumpet, right? The courts haven't bought this argument yet, because the issue was the federal government had not declared an invasion. They said this is for the feds to. Judge Ho, in a concurrence, said Texas can declare it, but the majority of the Fifth Circuit did not go that way. So I fully concede, and I give some of you, oh my God, Josh, I concede there's a startling argument as to its breadth, right? I got it. I'm not going to argue with that. But that conclusion is a direct consequence of the federal function that the Constitution assigns to the federal government and the states. It's there in the Guarantee Clause and the Invasion Clause. It's right there in black and white. It's been there for 220-something years. Now, I often hear argument, Josh, look, this can't be right. This can't be the right argument because the president or the state could declare an invasion anytime they wanted, and that's flat federal authority. Okay, I get that argument. But I think that argument downplays the fact that, in fact, millions of people are crossing the border every year. If this flow was stopped or heavily reduced, it'd be hard to justify this invasion argument. And I think even if the courts can intercede, political pressure prevails. In other words, the fact that it's so easy to say there's an invasion today is a byproduct of immigration policy the last several decades. Under this argument, the federal government disregarded its guarantee to the states to stop an invasion, which may justify unusual efforts now. And if Congress isn't happy with the actions being taken by the states and wants to remove the states' war power, there's a way to do that, which is to stop an invasion. Stop it. Now, some critics may argue that granting the federal government this power to override statutory law is a reason to reject such a broad reading of the invasion clause. Or stated differently, the fact that prior precedents have not declared an invasion, at least apart from asking Congress to declare war, suggests that the invasion power is not a trump card to federal immigration law. I think this argument only goes so far. If there's an ongoing invasion, and presidents have failed to address this crisis for decades, that would make the state's prerogative to act all the more urgent. Okay. The last point is the one about birthright citizenship. I'll mention this. So, cards on the table. I have long taken the position for a very long time that as a matter of original meaning, the children of illegal aliens are birthright citizens. That's my position. I'm sticking to it. Okay? People don't like it now. That's fine, but that's my position. A couple that's not lawfully in the country would still be subject to our jurisdiction, and their child would be a citizen at birth. Now some say, okay, Josh, duh, this is decided in the case of Wong Kim Ark. I don't think so. Wong Kim Ark was an 1898 case, is not definitive proof. That case concerned a child born to what we would now call a lawful permanent resident, or lawful permanent alien in the United States. Green card holder, basically, or someone with some sort of permanent status. I think that's the holding of the case, and if you read Wong Kim Ark, that's restated over and over again. People don't agree with me on this one, that's fine. But if the Supreme Court were to see this issue again, I think they should extend the holding of Wong Kim Ark to protect the children of illegal aliens. I'm okay with it. I think that's correct. Okay? That only goes so far. When I sort of did my research on this years ago, I didn't even think about the invasion clause. It wasn't even on my radar. That's some of the weird things that happens in recent years. Back in November, I did an interview with Judge Ho in the Fifth Circuit. And I sort of asked him, I said, Judge Ho, you've long taken the position, by the way, he was born in Taiwan. So I said, Judge Ho, you've long taken the position that the children of illegal aliens are birthright citizens. You wrote this opinion on the invasion clause. Is there any tension there? And people got very mad at me and saying, oh, Josh, he's auditioning. It's not. He's not auditioning. He told me which he hadn't said publicly before. He said, birthright citizenship obviously doesn't apply in case of war or invasion. And he said, no one, to my knowledge, has ever argued that the children of invading aliens are entitled to citizenship at birth. He said that. And I'm like, whoa, I hadn't thought of that before. And I think we should always try to keep open minds and be open to new ideas. And Judge Ho, as I say, he shifts the Hoverton window. He moves the realm of debate of what people talk about. And I think he's made some fair arguments. I think he's right. So Wong Kim Ark observed that the children of aliens within territory in hostile occupation would not be subject to the jurisdiction of the sovereign whose domains are invaded. In other words, if you are an invading force, let's say you're occupying a territory, and you give birth to a child, you don't get birthright citizenship there, right? You're occupying your hostile force. Now, just realistically, what comes before an occupation? An invasion, right? Just you invade a country. If you succeed, you occupy it. Like there's two steps. And I think that if you're the child of an invader, you likewise would not be granted birthright citizenship. Now, one of the Maryland courts that ruled on the birthright issue, about a couple days ago, feels like 2 years or a few days ago, recognized that the children of occupiers would not be birthright citizens. Again, the court acknowledged that the children of occupiers are not birthright citizens. That follows naturally from Wong Kim Ark. But then the court said in a footnote, by the way, when you're clerking, don't put important stuff in footnotes. That just means you don't know what you're doing, right? That means it's like you don't have much, and you say, oh, by the way, we're not going to talk about this. So don't do that when you're clerking. The court said in a footnote, this exception does not apply to the children described in Trump's order. Doesn't explain why. If the children of occupiers are not birthright citizens, then the children of invaders are not birthright citizens. I don't think there's much of an argument on this. In fact, scholars agree on this point. So one law professor from Northwestern said that invaders deny and destroy the jurisdiction of the United States. Another law professor from Berkeley said, if a child's parents are in the U.S. as an invading army, she would not be birthright citizen. This should not be controversial. Now, of course, in fairness, these scholars maintain that an invasion must be hostile. I get it. But if they're wrong on that point, and invaders can be non-hostile, the children of two peaceful invaders would not be birthright citizens. I don't know what the argument to the contrary is. Everything turns on what an invasion is. Now, curious thing, what happens if one parent is an invader and the other one's not? So imagine Mohammed Atta, remember who that is? The guy who planned the 9/11 attacks, was here for some time. He fathered a child here, and his wife was an innocent US citizen. Would that kid, he's an invader for sure, but would that child be a citizen? Actually, I don't know the answer. It's actually, no one knows, but I just threw it out there. Okay, so again, a lot turns in the essays I pose in this presentation. If the situation in southern border is an invasion, and the president can declare an invasion, then the federal statutes governing citizenship, and indeed the citizenship clause of the 14th Amendment, may give way. I don't think any of this is clear, but I think careful work must be done to walk through these issues. Thank you very much for your time, and I welcome comments from Mr. Mortensen.